The courtroom settles again, that quiet tension hanging in the air as everyone waits for the next move. The tribunal has reconvened, and Bola Tinubu's legal team is now stepping forward to continue their defense against the petitions challenging the presidential election. Documents are about to be presented, witnesses will take the stand, and every exchange could shape how the judges eventually see this case. So what exactly will the defense bring before the court today, and how will the petitioners respond? The courtroom had barely settled into silence before Tinubu's counsel rose to his feet. His voice carried the steady confidence of someone who had planned this moment carefully. He informed the judges that the matter before them concerned the second and third respondents. But before any witness could be called, there was something else the defense needed to do. Documents had been served to the opposing lawyers, he explained, and they were now ready to place them before the court. There were 18 items on the schedule. The number alone hinted that this would not be a quick process. One by one, the documents would be introduced, identified, and formally tendered as evidence. It was the kind of procedure that might look slow from the outside, but inside the courtroom, every step mattered. Each paper, each exhibit was another piece in the legal story the defense was trying to build. With the court's permission granted, the process began. The counsel started by presenting the first documents in the schedule. Among them were letters from the United States Embassy, along with reports connected to a former Inspector General of Police, Tafawa Balogun. As the documents were mentioned, copies were passed forward, and the formal language of the courtroom filled the air. But the quiet rhythm did not last long. Almost immediately, the Labour Party's counsel rose to object. His tone was firm. The party, he said, vehemently opposed the admission of these documents and did not consent to them being marked as read. Their reasons, he added, would be fully laid out later in the final address. For a moment, the courtroom seemed to pause on that objection. Then the judges spoke. Despite the protest, the court ruled that the documents would still be admitted and marked as exhibits. Just like that, the first set of papers became part of the official record. Tinubu's counsel did not hesitate. He moved forward, almost as if the objection had been expected all along. "My lords," he continued, guiding the court to the next item on the schedule. And so the process continued. Each new document was announced, described, and handed over. The defense steadily worked through the list, building a growing stack of exhibits before the tribunal. Every few moments, the same pattern returned: the defense presenting the document, the Labour Party rising to object, and the judges considering the matter. Again and again, the objections came. And again, the court admitted the documents into evidence. The rhythm became almost predictable. Papers were identified. Voices rose briefly in opposition. The judges ruled. Then the next item followed. To someone unfamiliar with courtroom procedure, it might have seemed repetitive. But for those watching closely, the moment carried a deeper significance. Each ruling meant the tribunal would have those documents available when it eventually weighed the arguments from both sides. By the time the defense finished working through the early items on the schedule, the courtroom had already witnessed a small but important battle, not over dramatic speeches or fiery accusations, but over paperwork. Yet in a legal fight like this one, those pieces of paper could carry enormous weight. And the defense team was not done yet. The stack of documents was still growing, and the courtroom could sense that the presentation was slowly building towards something larger that was still to come. The defense team was only getting started. After the first wave of documents had been admitted, Tinubu's counsel calmly turned the tribunal's attention to the next item on the schedule. The tone in the courtroom remained steady, but you could sense that each new exhibit was meant to reinforce the defense's broader narrative. This time, the document being presented carried particular significance. "My lords," the counsel said. Guiding the court forward, we now move to item 3. What followed was the introduction of the university certificate of the second respondent from Chicago State University. Alongside it, the counsel also produced a receipt for $1,000. According to the explanation given before the court, the payment had been made on the 28th of June 2023 relating to the certificate. The document was placed before the tribunal. Interestingly, none of the other respondents raised objections at that moment. But the pattern in the courtroom had already been established. The Labour Party's counsel rose once again to challenge the admissibility of the document. The objection was noted just as it had been before, and just like before, the court admitted the document anyway. The process continued almost without pause. Tinubu's counsel turned next to the data pages of the respondent's Nigerian passport. These pages were shown to the court and formally tendered as part of the evidence. The judges reviewed them briefly, and again the same courtroom rhythm returned objection from the Labour Party consideration by the bench and admission of the documents into evidence. Then came another set of exhibits. "My lords," the counsel said, "I seek to tender items 10 and 11 together." These documents related to party membership records. One was a submission letter forwarding the registration of members belonging to the second petitioner, dated April 25, 2022. The other concerned the registration of those members in Anambra State, certified by the first petitioner. Once again, the Labour Party objected, but once again the court admitted the documents. The stack of exhibits before the tribunal continued to grow. Tinubu's counsel then asked permission to take several other items together, numbers 6, 7, 8, and 9. These were connected to visa records issued by the United States. One visa had been issued in February 2011. Another document was the data page issued in July 2017. Two more visa pages followed, issued in July 2019 and November 2021. Each page was presented, examined briefly, and added to the record. The courtroom had now settled into a familiar cadence. The defense would present a document. The Labour Party would object. The judges would deliberate for a moment. And then the exhibit would be admitted. But the list was still not finished. The counsel continued by tendering a certified true copy of the report of the committee responsible for the location of Nigeria's federal capital territory. From there, attention shifted to election materials. Certified forms connected to the February 25th presidential election in Kano State were also introduced before the court. This time, something slightly different happened. When the Kano election forms were presented, the Labour Party's counsel looked over the certified copies and announced that they would not object. The decision, he explained, was consistent with the agreement reached earlier during the pre-hearing stage. Even so, the process remained careful and deliberate. Each document was formally acknowledged and admitted into evidence. By now it was clear that the defense strategy was unfolding piece by piece. A long trail of official records, certificates, travel, documents, reports, and election materials was being placed before the tribunal, building a paper record that the judges would eventually have to weigh when the legal arguments reached their final stage. After the long stretch of documents had finally been placed before the tribunal, Tinubu's counsel paused for a moment. The courtroom had settled into that familiar rhythm of legal procedure, but now something slightly unexpected happened. The counsel stood again and addressed the bench with a small request. He explained that the defense was ready to continue and even ready to call their witness. But there was a practical problem. The colleagues he would normally delegate tasks to had briefly stepped out of the courtroom and had not yet returned. With a touch of humility, he reminded the court that everyone was human and asked for a short break so the team could regroup. The judges considered the request and granted it. For about 10 minutes, the tension in the courtroom eased. Lawyers shuffled through papers. Quiet conversations began, and the steady hum of preparation filled the space. But the pause did not last long. Soon enough, the tribunal reconvened and Tinubu's counsel rose again, this time ready to proceed. Now the defense was calling its star witness. The man stepped forward to the witness box and introduced himself when asked for his name and address. He explained that he lived in Abuja and confirmed that he was a legislator. His background was quickly laid out before the court. He held a bachelor's degree from the University of Ife and had later obtained a law degree from the University of Benin. After that, he attended law school and became a barrister. All of these details, he confirmed, were contained in his resume. Tinubu's counsel then asked the court for permission to tender that resume as evidence. There were no objections from the other lawyers in the room, and the document was admitted without controversy. From there, the questioning moved forward. The witness was reminded that he had previously visited the court registry on April 12, 2023, where he submitted a witness statement on oath. The counsel showed him the document and asked if he recognized it. The witness confirmed that it was indeed his statement and agreed that he wished to adopt it as his evidence before the tribunal. With that confirmation, the defense formally tendered the witness statement. But the testimony did not stop there. Tinubu's counsel began guiding the witness through several portions of that statement, pointing to paragraphs where different documents had been referenced. The witness was asked to identify them if they were shown to him. One set of documents related to election results from Kano State. The witness explained that in his statement, he had discussed the results and pointed to forms that recorded those figures. When the forms were presented, he carefully examined them and confirmed that they were the same documents he had referred to, even indicating the specific column where the relevant figures appeared. Another reference in his statement concerned reports from international election observers. When shown the report, the witness again confirmed that he could recognize it. Little by little, the foundation of his testimony was being laid before the tribunal. Once the witness had finished confirming the documents referenced in his statement, the moment arrived that often changes the tone of any courtroom proceeding. It was time for cross-examination. The lawyers, who had been listening quietly now, had their chance to challenge, test, and probe what the witness had just said. The first opportunity went to the lawyer representing the Electoral Commission. He stood addressed the witness politely, even referring to him respectfully as a distinguished senator. For a brief second, it seemed as though a line of questioning was about to begin. The witness answered calmly when addressed, but then something unexpected happened. After that brief exchange, the lawyer simply said he had no questions. Just like that, his turn ended. For a courtroom that had been bracing for confrontation, the moment felt almost anticlimactic, but the quiet did not last long. The next lawyer stepped forward, counsel representing the APC, and this time it was clear that the questions were coming. He began by asking the witness about his background, referencing his previous role as chairman of the Senate Committee on Judiciary, and noting that he was now the Senate Majority Leader. The witness confirmed this without hesitation. The lawyer then turned the discussion toward some of the documents that had already been tendered in court. One particular point caught his attention. The counsel noted that an exhibit earlier mentioned did not contain the name of Peterobi as a member of the Labour Party. The witness confirmed that this was correct. From there, the questioning shifted slightly toward legal procedure. The lawyer asked whether, as a U.S. practicing attorney, the witness understood that a conviction cannot exist without a formal charge and indictment. The witness replied that he did understand this principle. Then the counsel pointed toward the documents already before the court, suggesting that they showed the second respondent had no criminal conviction recorded against him. The witness agreed, but the exchange was only beginning. The lawyer then asked a new question. Did the witness have his New York bar membership papers with him? The witness answered that he did. That response immediately caught the court's attention. The APC counsel asked for permission to tender the document along with other related papers. When the materials were presented, however, the presiding judge leaned forward and studied them closely. What followed was one of those moments that quietly shifts the atmosphere in a courtroom. The judge was not convinced. Looking carefully at the card that had been presented, he observed that it did not clearly indicate New York. The counsel attempted to clarify, saying it should be understood as an American bar document connected to New York, but the judge was still not satisfied. To him, the card looked more like a complimentary card than an official identification. The explanation that followed was almost a conversation. The counsel tried to describe how legal practice works in the United States, explaining that attorneys may initially be tied to a particular state, but can later practice more broadly. The witness added that membership in the American Bar Association is common among lawyers. Still, the judge examined the card again. He repeated that it appeared to be a complimentary card rather than an official ID. The witness responded that it was the card he used in practice. The judge pointed out that the two cards before the court looked identical and expressed difficulty in accepting them as formal identification. At that point, the witness offered another explanation. He said that lawyers often receive these cards regularly and that he had several of them. The judge then asked a simple question: which one was the most recent? The witness reached for another card. This new card was produced and presented to the court. The APC counsel immediately moved to tender it as evidence. As expected, the Labour Party counsel objected to its admission, but the court ultimately allowed it into evidence anyway. The moment carried a mix of tension and quiet humor. What had begun as a straightforward question about legal credentials had turned into a careful inspection of a lawyer's identification card. The bench remained cautious. The lawyers tried to clarify their positions, and the witness stood there navigating every question. It was a reminder that in a courtroom like this, even the smallest document can suddenly become the center of attention. If the earlier exchanges had felt measured and procedural, The mood in the courtroom shifted the moment the Labour Party counsel rose for his turn. Everyone in the room knew this was where the real pressure would begin. Cross-examination is never gentle, and this time the questions came with a sharper edge. He started calmly enough, reminding the witness of something already established. The two men, he said, had a long-standing professional relationship. The witness acknowledged that. Then the lawyer asked a direct question: did he know that Bola Tinubu was a Nigerian citizen by birth? The witness answered simply yes, but the lawyer was not interested in lingering there. He immediately directed the witness back to his own statement on oath, pointing out specific paragraphs where the witness had mentioned reports from both local and international election observers. The witness confirmed that he had indeed referenced those reports. At that moment, though, the counsel noticed something. The witness appeared to be looking down at a document in front of him. The reaction was swift. The Labour Party counsel told him to close whatever he was reading and look up. As a lawyer himself, the witness understood the rules of the courtroom. The message was clear: the questions required direct attention. Then the documents came out. The counsel approached with the European Union Observer Report and asked the witness if he could recognize it. The witness confirmed that he could. The lawyer then moved to tender the report as evidence. Immediately, the lawyers representing the respondents jumped up with objections. One of them pointed out that the document had already been tendered earlier in the proceedings, though in connection with a different case before the tribunal. There was a brief exchange between the lawyers and the bench as they clarified the situation. In the end, the judge allowed the document to be used. The Labour Party counsel then turned to the content itself. He asked the witness to consider a particular section, page 60, paragraph 6, and read the passage aloud. The portion he read referred to election results that were reportedly not readable and had not been uploaded to the official reporting system. The courtroom grew quiet as the words were spoken, but the questioning did not stop there. The lawyer then shifted to another report, the ECOWAS Observer Report that had earlier been introduced by the defense itself. He directed the witness to paragraph 17 and asked him to read it out. The witness complied. The passage described incidents of violence during the election period, including killings recorded in several states. For a brief moment, the weight of the words seemed to linger in the air. Then came the unexpected twist. After reading the paragraph, the witness said he did not agree with what the report stated. The Labour Party counsel immediately seized on the remark. He asked how the witness could disagree with a document that he himself had tendered before the court as evidence. The exchange carried a touch of irony, and the tension in the room rose another notch. But the questioning was only warming up. The lawyer began moving into a different area entirely: U.S. legal matters connected to earlier allegations that had been part of the wider political controversy surrounding the case. He asked the witness about the forfeiture of $460,000 by a U.S. court, and whether that order stated that the money represented proceeds from narcotics trafficking. The witness responded carefully. He explained that the matter involved a civil forfeiture, not a criminal one. But as he began trying to elaborate, the judge intervened. The presiding judge reminded him that he was appearing before the court as a witness, not as an advocate. The instruction was simple: answer the question directly. The questioning continued. The Labour Party counsel pressed further, asking whether the witness had access to the election result viewing portal during the presidential election. The witness said he had not accessed it. The lawyer then suggested that if he had never accessed the portal, he could not confirm whether the uploaded results were readable or not. The witness disagreed with that conclusion. The conversation kept shifting between legal details and election issues. At one point, the counsel referred to the U.S. court order, again mentioning specific legal provisions and asking whether the judgment relied on sections connected to money laundering laws. The witness acknowledged that the provisions had been referenced, but maintained that the matter remained a civil forfeiture case. Another question followed about a letter from the U.S. Embassy that had earlier been tendered in court. Did the embassy report mention any response regarding money laundering allegations tied specifically to Tinubu? The witness answered that the response was general and did not mention him. At one point, Tinubu's lawyer tried to intervene, urging that the witness be allowed to finish his explanation. The Labour Party counsel pushed back sharply, insisting that the interruption was eating into his time. The judge stepped in again, allowing the questioning to continue. By now, the courtroom felt charged with that peculiar energy that only intense cross-examinations produce, lawyers pressing witnesses, responding carefully, and the bench watching closely to keep the exchange within bounds. After the long stretch of questioning, the intensity in the courtroom slowly began to ease. The Labour Party counsel indicated that he was done with his questions, and the witness remained standing calmly in the box. What had just unfolded was one of the most charged parts of the day's proceedings, but now the atmosphere was shifting again, this time towards something lighter. The presiding judge glanced toward the witness and made a remark that caught everyone slightly off guard. With a hint of humor, he said he hoped the lawyer who had just conducted the cross-examination would not find himself appearing before this same witness one day in the Senate. The comment triggered laughter across the courtroom. The Labour Party counsel quickly responded, playing along with the joke. He said he was not in any hurry to leave what he was currently doing. That reply drew even more laughter, and for a moment the tension that had filled the courtroom earlier dissolved into a brief wave of amusement. But the proceedings soon returned to business. Tinubu's counsel rose and informed the tribunal that there would be no further examination. The witness, he explained, had testified on behalf of both the second and third respondents. With that, the defense confirmed that their case had come to an end. The judge turned to the courtroom and asked if there were any objections to closing the case. None were raised. Shortly afterward, the APC counsel also addressed the bench and confirmed that the witness who had just testified represented all of the respondents, including the first respondent. There would be no additional witnesses from their side either. That announcement effectively brought the defense stage of the proceedings to a close. The presiding judge then laid out the next steps. Each of the respondents would have 10 days to file their written addresses. The petitioners would then have 7 days to submit their reply. After that, there would be another 5 days allocated for final filings. The court would notify all parties of the date when the final arguments would be adopted. And with that, the tribunal moved one step closer to the moment everyone in that courtroom and far beyond it was waiting for. With the defense now officially rested, the case quietly shifts into its next and perhaps most decisive phase. The lawyers will soon return with written arguments, and the tribunal will begin weighing everything that has been placed on record. Somewhere ahead lies a judgment that could shape how this entire election dispute is remembered. Until then, stay with the story as it unfolds. And if you want to keep following each step of this process, feel free to like the video and subscribe for the updates ahead.